Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation, and you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Okay, good morning. We're here on our criminal miscellaneous docket. Ms. Merrifield? Is she here? No.
Saw her this morning, Judge.
I believe she may have just stepped out, Judge.
She's here a minute ago.
Yeah, Your Honor, I just spoke to her, so I
That's all right. We'll wait. We'll pass over. Mr. Gilbert?
I believe she went outside.
Mr. Gilbert speaking with his,
Oh, okay.
he's speaking with his client in the attorney.
Okay, that's all right. Okay. Thank you. David, Mr. Rare's not here. I mean, he's here.
He signed up.
That's all right. Mr. Niddle,
I'm here, Judge.
you're here.
Marion Pride and the
It should only take a few minutes.
Pride select.
Judge, before the court is Jamarian Pride, we're here on a motion to reduce his bond. Just a brief summarization, he was arrested on February 26th of this year. So it's 3 separate counts. At his first appearance, he was arrested as a juvenile. So when he went to first appearance, he was ordered held on no bond. And then it was transferred to adult court, and Mr. Medina was representing him and filed a motion to set bond, and on April 14th, his bond was set at $50,000 each count for a total of $150,000. He's currently 18 years old. He lives in Mary Esther with his, he's never been in trouble before. He was determined to be indigent, and he cannot afford a high bond.
When was the bond set?
Actually, it was set, I believe, on April the 11th or April the 14th. I was just looking at the docket.
Okay.
He was originally held on no bond, and he was represented by the public defender once it was transferred to circuit court. And Mr. Medina filed for a bond hearing, and it was set at $50,000 each count. Obviously, he can't make that bond. He's still in jail. That was back in April when that was set. I can have him sworn in. I would like to ask him a couple of questions, if the court please.
Sure. If you please raise your right hand, Mr. Pride. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Here's the answer.
Yes, sir.
Put your hand down. You're Jamarian Pride, is that correct?
Yes, sir.
Mr. Pride, where would you live if you were to be released on bond?
In Mary Esther with my guardian,
And what is their name?
Adrian Thomas.
Okay. And who is Mr. Thomas to you besides your guardian? Is he a family member?
No, sir, just my guardian.
Okay.
So you're a legal guardian?
Yes, sir.
Or was? He is currently or was? When you were juvenile, you mean?
No, she is currently still.
Somebody's have to explain that to me because I don't understand that. It's an adult.
I'm not sure about it either, Judge. Why was he appointed as your guardian?
No, it's a lady.
Why was she appointed as your guardian?
Because when my mom went to prison,
Oh, okay.
she's my guardian.
Were you in school when you got arrested?
No, I was trying to go back though
What school did you go to?
for Beach High School.
And you were trying to go back, you mean you were trying to get readmitted to there?
Yes, sir.
What grade did you complete, your last completed grade?
9th.
And when did you last attend school?
2021.
Okay. And you understand that if you were to be released on bond, that you would be required to appear for court?
Yes, sir.
You have transportation to and from court,
Yes, sir.
and you have a place to live?
Yes, sir.
If you don't make it back into school, what is your intentions? Are your intentions to get a job?
Yes, sir. And to get my GED.
Okay. We're asking that, Judge, we're asking that his bond be set at $20,000 or less, a blanket bond. I don't know if Mr. Sharp has any questions for Mr. Pride.
Your Honor, I don't have any questions for Mr. Pride, just argument when it's appropriate.
Mr. Niddle, what's the status of the case?
We had filed a motion to dismiss. It was traversed based on some, I don't want to get into the argument there, but basically, there was one witness that didn't show up at the last.
I'm just looking at a status. I don't need to get into the
January
substance.
4th, we have deposition set. And once that's done, we should be either, I'm going to file another motion to dismiss or set it for trial, one or the other.
Okay. Do you have any other witnesses?
No, sir.
You wish to make the closing argument?
Judge,
I mean, you kind of already have, but if you need to add anything else.
no, nothing really. I mean, this is a young man who's never been in trouble before. I think eventually he will be exonerated of this charge, or if not exonerated, at least acquitted. I believe that he's been in jail 10 months, and the evidence is sketchy as it regards to him, let's put it that way.
Well, just as a general rule, before I make a rule, and the state's going to have their chance, there's two ways that we can deal with these. One is to move these cases. So we're a year out. So I'm just saying, he's been in jail because we haven't moved this case. So everybody can jump on this thing and start moving these cases a little bit, and it'll go faster. Just as a general comment. Counsel for the state.
Your Honor, these cases, and I will say that there are 5 co-defendants. It's been very complicated to get depositions set with counsel and counsel for the co-defendants. And there were situations where almost everybody got appointed as public defender and then had to withdraw. So there has been that situation where moving the case. The state has nothing to add that wasn't said at the prior bond hearing. The court set the amounts at an appropriate amount that it felt was appropriate for these charges at the April bond hearing. Nothing's changed. The court, there's no new information for the court. Mr. Niddles has brought things up that are jury questions and not appropriate for a bond hearing, Your Honor, and the state's requesting that the bond remain the same as the court set in April.
Has there been any change of circumstance, Mr. Niddle?
Well, other than that, we've done the depositions, and now I know the strength of the case against Mr. Pride.
Let's get this case to trial. Court's going to deny it. There's not been a really change of circumstances. These are very serious charges. That's why it was set that high. I don't see a basis to decrease it at this point. But I am interested in getting this case. You have a right to have your case, dealt with, and that's the thing I'm going to be focused on.
Well, hopefully the remaining officers will show up for their depositions on January 4th, and we can set this for trial.
And if not, the court will be supporting every effort you have to get these cases and get the deposition set. I'll be in your corner on that one. Okay?
All right.
Okay.
Thank you, Judge.
Thank you very much.
See you later.
I think that's your only case, Mr. Niddle? Yeah, that's all right. That's all right.
Any plans?
Gilbert?
Yes, sir, and I have a different list than you, so I'll be going.
I need the signatures.
That what we, I thought I was the guidelines.
Oh, you did.
Tiffany Bland.
This is for the violation of the FDA from the legal cases that is being not pursued.
You can say, tell us, I said that too. You can say it, really?
Your Honor, may I approach?
No, I don't. You may. Mr. Gilbert, would you please announce the plea?
Yes, Your Honor. We're here this morning with Ms. Tiffany Bland in 23 CF 2537. There was a related DUI at 23 CT 2645, but I believe that's been merged into this as I looked at the site last night. She's present, and we offer this plea and resolution of the case, both cases.
So the 23 CT 2645, somebody got to explain this.
So as I looked on the clerk page this morning, it is now the second count of 2 counts in 23 CF 2537. The first
Should
two,
the clerk's case number still be on there? Is it merged in there? Is it one case or what? I just want to make sure it's,
The cases have been consolidated into the CF case, and the CT case is closed out.
okay, so,
I put it in parentheses, so if we want to just scratch that out. This has become a problem in the past, Your Honor.
no, and I'm not, I just want to make sure we're all clear. That's, okay, go ahead, Mr. Sorry.
And so she pleads state's agreement and a defense agreement is provided in the last addendum.
Okay, why don't you go ahead and announce it?
Well, may I have the... Your Honor, state defense's agreement is on count 1, driving on a suspended license, second or subsequent. Adjudication will be withheld, 6 months community control with GPS at reduced rate, 2 years of probation, and fines and costs. In count 2, DUI second within 5 years. If you're adjudicated guilty, 30 days jail, credit for time served, 1129 probation, 5-year driver license suspension, 90-day scram, DUI school and victim impact panel, interlock device for 1 year, 30-day vehicle impoundment, $1,000 fine, and costs. All of that to be concurrent with count 1. May I approach?
Is the state in agreement? Ms. Bland, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So, Ms. Bland, you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea and sentencing agreement. Have you read this plea agreement closely?
I have.
And have you gone over it in detail with your attorney to make sure you have, understand what, all the legal ramifications of this plea agreement?
Yes.
Importantly, understand you're waiving the right to go to a trial, some other valuable legal rights. You're doing that in order to get a final resolution of this case.
Yes.
Is that what you believe that's in your best interest to do that here today?
I do.
Okay. Nobody threatened you or coerced you to get you to enter into the plea? Okay. Based upon that, the court will accept your plea as to count 1, driving on a suspended license, second or subsequent. There'll be, an adjudication will be withheld. You'll be sentenced to 6 months of community control with the GPS at a reduced rate. What's the reduced rate? Like $1?
$1 we'd ask.
Okay. we'll go ahead and put that on there. I'm going to give it back to you in a second. Just put it on there. 2 years, is that 6 months of community control followed by 2 years probation,
No, Your Honor.
or part of the probation?
Part of the probation.
So you got to clarify that too. Okay, we got to make sure these things are clear.
Yes, sir.
So that there's nobody, your client and everybody else is clear.
Absolutely.
So it's 2 years of probation, the first 6 months,
Is community control, GPS.
and what are the fines and costs? Madam Clerk?
It's going to be $683 for court costs and
Counsel.
$500 fine.
And I apologize, Madam Clerk, I didn't hear the costs.
$683 court costs and $500 fine.
And then the cost on, well, that's it.
Okay. So, the 6 months of community control will be part of the 2 years of probation. And as to count 2, the DUI, second in 5 years, there'll be an adjudication of guilt. You're sentenced to 30 days in the county jail. You will get credit for all time served. And in addition to that, you'll be sentenced to 11 months, 29 days probation. And that will be concurrent with count 1. So it's really the 2 years will kind of override everything. Not override, but that's the total amount. There'll be a 5-year driver's license suspension and 90-day scram. Obviously, the other standard, the DUI school, victim impact, interlock device for 1 year, and 30-day vehicle impoundment, $1,000 fine. What are the costs on the DUI, Madam Clerk?
$683.
I'm sorry?
$683.
That's in addition to the count 1? Counsel? Put that in there. So, ma'am, is this your understanding of what all the agreement is? I just want to make sure that we clarify so you're clear about what you're agreeing to in this. Yes? Okay. And is the state in agreement with all these details?
Yes, Your Honor.
It's important that when we have these plea agreements, that they be clear for the defendant to understand it so they'll withstand any type of appeal. If we don't have it clear, then it won't withstand appeal. Because the final thing is you do have 30 days to appeal this, even though you're agreeing to it here today. Okay? Okay, good luck.
This way. Also this morning, you called us for a status hearing on Christopher Bates and 20 CF 787.
Where are we at?
So, Your Honor, we had a case management meeting on this about 3 months ago, and we've tracked right along with the plan. Defense has completed depositions last week. We may have some to catch up that missed out, but I'm not recalling any significant witnesses, so we're pretty much ready.
Okay. State?
Your Honor, the state had previously stated that we would be ready for the March 4th trial cycle. Part of that is the defense has an expert. They haven't given us any information on what he might testify to yet, so we need that information from the defense. We might need to depose that expert. And we do have some highway patrol that are stationed in Keys and elsewhere throughout the state that are on this case that we're monitoring. The state will be ready for the March 4th trial cycle.
Okay. Very good. When do we want to come back? Let's just come back on our regular pre-trial in February 12th. That'll be about, well, actually, that will be part of that cycle.
That is why, Your Honor, we'll be ready by next cycle.
So you feeling comfortable you'll be able to get whatever discovery you need prior to be prepared for that trial cycle?
Yes, Your Honor, we don't see anything holding us up now.
One thing I would offer is that if along the way there's any, because there are a couple of steps, a couple of key depositions and follow-ups that are necessary in order to be prepared for March. If for some reason there's problems, come right to the court. Get to the court, get on a miscellaneous docket, and review it. The court will be glad to try to assist, try and make sure that this is a priority item. Okay?
Thank you, Your Honor.
Thank you very much.
The state will have all motions filed for the next trial.
Very good. Thank you very much. So we'll continue this until the next pretrial, which is 2/12.
Thank you, Your Honor.
Thank you, Mr. Gilbert.
And that concludes my business report, Mayor.
Thank you. You may. Mr. Shaw.
Let me get my little dollar here.
Morning, Judge.
Good morning.
Tim Shaw for Cameron Churingia, 22 CF 87. Judge, this case was put on for a status conference. Mr. Patel and I were retained to represent Mr. Churingia for Mr. John Reed, who, as the court's aware, moved on as the magistrate. There had been, and for some reason, it didn't get put on a pretrial docket, is my understanding. So we're just wanting the court to put it on the next pretrial docket.
And Your Honor, the court may or may not recall, we had a motion to suppress hearing with Mr. Reed. We had put on the first witness for that. He had questioned him as far as everything that was required as the motion to suppress the search warrant. Mr. Reed was supposed to let us know whether or not he was ready to proceed to closing arguments on that, or whether or not he wanted to recall the witness for some further questions that had come up. That motion hearing had been reset for June, but subsequent to that, Mr. Reed got off the case. So what the state was also trying to determine is, and I've reached out to Mr. Shaw in his office a couple of times, is whether or not we need to finish up that hearing because it's still kind of sitting out there, the motion to suppress. And also, I wanted to make sure we got back on a docket because we were just sitting out there. So we do need a pretrial date, but we also need to figure out where we are with that motion to suppress.
Judge, I would suggest we go ahead and put it on a date to complete the motion to suppress. And if we don't need it, of course, we can just tell the court that at the time or ahead of time. We just need to get it wrapped up. So if we want to get a motion date out, then we can do that, or a miscellaneous date along with the pretrial date. That's fine.
How long do you anticipate? Well, it'll be an afternoon miscellaneous, so no matter what.
And
so figure out, kind of estimate what you think it is, and call Miss Eileen. She'll be next week, and we'll get it on the calendar.
And Your Honor, the state had actually already was completed with putting on their witness for the motion to suppress hearing. We were actually already done with that part of it. So that's what I'm trying to figure out is where.
Yeah,
where will they be picking up?
We're gonna, if we're gonna need to get a transcript of that for the court, and I want to make sure that even with notes are not sufficiently detailed. I'm going to want to look at the trial transcript. We're going to be able to get that transcribed.
Mr. Shaw had indicated he was going to have that done previously. I don't know if that's still the intent, sir, or...
That's the intent. We'll go ahead and request it and have it transcribed.
What I would suggest or ask is that it be transcribed and given to me before the hearing.
Sounds good,
In
Judge.
other words,
Thank you.
I'll then reread it, so we'll be coming in as if we're finishing it up, and I might, it would be my intent maybe to, if possible, not on, but, you know, my intention would be to try and make a ruling there right at the hearing. So rather than have the hearing and then come back later with the transcript and then have to come back again with a pronouncement.
That would be great, Your Honor. So you want us to get with Miss Eileen, though, as well, to set the date?
But kind of tie it in to being able to get the transcript to me maybe a week before whatever that date is, before the date of the hearing, so that I can review it.
So we're probably looking for a February date, I think realistically, prior to our
And that's
pre-trial.
probably pretty good as far as scheduling anyway.
Sounds good, Judge. And we'll reach out to Miss Eileen if you put us on the pre-trial docket, perhaps, so we don't fall off again.
That's fine.
And then Mr. Shaw and I will work with Miss Eileen, and Mr. Shaw will get the transcript, right?
That's correct.
Okay, great.
So the
Thanks, Judge.
pre-trial is February 12th.
Thank you.
9 a.m. Thank you.
Thank you, Judge. That's all I have.
Okay, thank you. Have a great day.
Thanks, Tim. Let me know if you need anything on that.
Mr. Lair.
Mr. Ware.
Does that have another 10, 15 minutes to reply?
If you wish, sir.
Let's see. Stephen's got
Mr. Harper?
Yes, Judge, mine are all in custody. I don't know if there are others out of custody that can be addressed, but I'm ready to go.
Sure. Mr. Medina or Mr. Gates, do you have any that are not in custody that you would like to kind of take care of before we start bringing in the inmates?
I have not been able to assess that, Judge. I haven't stopped.
That's fine.
Together.
That's fine. I'm just offering it.
I'll figure that
Yes,
out in a
ma'am.
minute, hopefully.
There is a Mr. Bloodworth on the docket, that's all I
He's
have.
in custody.
Today. For a bond hearing, it will be on focus by the state.
Okay, hold on a second. Where's?
It's an inmate, Your Honor. I
Okay.
have not spoken to him this morning, but he can come out if the state wants to stipulate.
Hold on a second.
I have him as number 17.
Okay.
I don't think he's going anywhere in the next hour, so I don't know if we want to do him before we're out of custody.
You know, let's go ahead and do it if this is your only case.
Yes, Your Honor.
Yeah, we'll do it so you should go on through it.
Yeah, I got you. Steve Medina with John I. Bloodsworth in, let's see, docket number 2 from the 130 docket, but he was also on the 17 docket this morning for a bond hearing. And my understanding in 23 CF 2539 is that the state is indicating that it will stipulate to his request for a bond reduction to a signature bond. My understanding is his bond is, the present bond is $5,000 cash or professional, so the state would be stipulating to conversion of that to a signature bond.
Is that correct?
Your Honor, He was actually on no bond for a violation of probation. It turned out that the probation was actually terminated back in 2022, and the state has filed a no cost on the DOP.
Thank you.
So the state would stipulate to bond. We would ask for cash and professional, and no contact order with the victim in the 23 CF case.
Well, Your Honor, then we don't have a stipulation, because my understanding, I mean, the defendant's motion for bond reduction was a motion for a signature bond. He has a $5,000 cash or professional on a new law battery charge in 23 CF 2539. So I guess we need to go forward with the bond hearing if the state's not stipulating to it.
In that case, the state will stipulate the signature bond.
So, Your Honor, I don't think we need to go forward then. It's just a
So
misunderstanding.
let's make sure that we're clear about what are the conditions of the bond. Is this still, you're seeking no contact with the victim?
Yes, Your Honor.
So, Your Honor,
That's a part of that. I just want to make sure everybody's clear about it. That's very important. I mean, I don't know the circumstance of the victim, or were they living together? Okay.
Your Honor, so as I understand it, I appreciate the state's cooperation. The pretrial conditions would remain unchanged, including but not limited to the no contact order with respect to the alleged victim. And it would just, the only thing that would be changing would be the amount of the bond would just be changing to a signature bond from a cash or professional. No other changes. Is that correct, ma'am?
Okay. With that stipulation, that clarification, court will grant the stipulated bond reduction. So the VOP, the no bond of the VOP, that probation has gone away, so that the no bond part of it goes away because that case has gone away. That's what the state just said. I don't know what that number is. But under this was previously a $5,000 cash professional. It's going to signature with all of the pretrial services, not pretrial, but pretrial conditions.
Yes, Your Honor.
And then just to understand about the no contact, this is one-sided no contact. I don't know the details, so I just want to make sure that if somebody walks up to you in public, you
Your Honor,
got to stay away.
Mr. Bloodsworth tried to tell me something, and I was trying to listen to the court and the state. So may I have a moment with him?
Thank you, sir. That's right. Thank you.
Your Honor, thank you, Your Honor. His next court date will be February 12th.
Did you say that he was also on the arraignment docket this afternoon?
Yes, Your Honor. We would go ahead and waive arraignment and enter not guilty.
Okay, hold on a second here.
That was docket number 2 from the afternoon. Thank you.
Yeah, very good.
And he would
So
remain
we'll enter
on.
not guilty on the, actually this same case number 23 CF 2539, Madam Clerk, for this afternoon. And then we'll come back on the next pretrial.
Yes, Your Honor. So he can be on February 12th since he's getting out of jail.
Very good.
And I'm writing it down for him.
Okay, great. Thank you.
All right, man. That's the next court date. Contact me, set an appointment. Thank you.
Your Honor. Appreciate you. Thank you, ma'am.
Thank you.
Your Honor, if I can call my one out of custody,
Sure.
Dayton Gregg, should be number 10 on the docket.
Very good.
Mr. Gregg and I have talked about the plea agreement. My expectations will enter an admission to VOP. If I can have Mr. Gregg sign the plea agreement. We discussed the terms prior to him coming up, Your Honor. It is a CC, reinstate with CC, community control. I did give him some paperwork explaining what community control is going to be.
Do the score sheet. Okay.
You want to make it first? It is going to be a reinstate modify, so there will be no score sheet filed in this case.
Thank you.
Thank you.
Would you please announce the plea?
Yes, sir. Mr. Gregg will be entering an admission to the violation before the court in 22 CF 1893. We're going to maintain the withhold, modify, and reinstate his supervision, placed on community control for the balance of his supervision, weekly UAs, 2 NA meetings per week for the first 3 months of community control, substance abuse eval within 30 days, and you recommend treatment within 60 days, complete the original requirements, $100 cost of prosecution, $150 public defender fee, and counts 2 and 3 were misdemeanors, and we're already past expiration on those, Your Honor.
State?
That's correct.
Okay. Mr. Gregg, would you please raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of the plea agreement, same as before. You can put your hand down. And I see you've signed that plea agreement. Just want to make sure you understand you're waiving the right to contest these violations of probation. And by entering this will be a final resolution of your VOPs.
Yes, sir.
Okay, you understand that? But
Yes,
you
sir.
are giving up some rights to get here. You've
Yes,
gone over those with your attorney, make sure you had all your legal questions answered.
Yes, sir.
Okay. Based upon that, entering this freely and voluntarily?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. There'll be maintain the withhold of adjudication on both counts. And these are for the felony VOPs, counts 1 and 4. You'll modify and reinstate probation. Defendant will be placed on community control for the balance of the supervision, the balance of the probation. There'll be weekly UAs and 2 NA meetings per week for the first 3 months of community control. Then you must do the substance abuse evaluation within 30 days and start any treatment in 60. That's important. You got to get on that. Complete all original requirements. Then you've got, of course, the ever-present additional fees and costs. And counts 2 and 3 are past expiration, so we don't have to worry about those. Any questions?
No, Your Honor.
Okay, good. Anything, State? Did I miss something?
I just want to clarify on the record.
Sure.
So the weekly UAs and the 2 NA meetings per week for the first 3 months of CC, that's...
No, the way I read this, and the question, because there's no comma here. I do this as there's weekly UAs. Let me ask the question. Are the weekly UAs only for the first 3 months?
Yes, Your Honor. That was the agreement with the state.
Then the way it's worded in here is correct. There is no comma after weekly.
Yeah, and that's why
I can't believe we're getting into this, but
that's why I brought it up, because I just want to make sure because we knew what our agreement was, but we'll make sure we're communicating it well with the court.
okay. Well, it's a nuance, and so to clarify, the weekly UAs and the 2 NA meetings per week are only required for the first 3 months of community control.
That's correct.
I actually wasn't completely clear on it, so I appreciate your...
And I appreciate the court...
And that is accurate, non-placement of comma to make sure that that's clear.
Oxford comma is what I was going to say, Your Honor. I typically use the Oxford comma.
What is, I'm afraid, what is the Oxford comma?
The last comma before and.
Very good. Well, if you place it there, then it breaks the clause up, and it makes a different meaning. Anyway, I'm sure everyone is very glad to hear that English lesson.
Yes, Your Honor. And Mr. Gregg does reside in Walton County. I'd explained to him to have to report to probation here and then start reporting in Walton County.
Yeah, they'll help you figure out how to be able to report in Walton.
Yes, sir.
Okay. Sure, check in today. Okay, Mr.
Judge, I'm ready to go if the court permits.
Let's go.
Number 7, Kathleen G. She's in custody.
Okay.
We'll take the G.
Both G and Hall. G, left turn.
Judge, this is Ms. G before the court on 23 CF 1674, 23 CF 2204, and 23 CF 2565. Judge, we've moved these cases to today to try to resolve this. I think there's still an outstanding issue that the state is working on, if possible, and if the court will permit, in the hopes of making a resolution as soon as possible. If we can move it to this Thursday, if the court would permit that. We intend to enter in a plea. It's just a matter of making sure all the paperwork is in order.
Okay, I'm trying to make some accommodation for the juror review. Just don't want to.
Yes, sir.
I don't want to make it a habit, but we're trying to move some cases on this. This is a little bit of a unique situation, and we've got time. So we'll come back on juror review
This Thursday.
on the 21st. 12/21.
And just so the court knows that last case, I have spoken with Investigator Cooper. I'm getting
Which last case are we talking about?
the 2565 case. So she has several new cases.
Okay.
And in that case, I do need some more information from the investigator before I can get Mr. Harper an offer and engage in discovery with him. And Investigator Cooper is aware of that, and he's working on getting me the information I need, and hopefully by Thursday we'll have that.
And in all fairness, Judge, I did move these cases up. That last case was set for February, but in the interest of trying to resolve it.
Particularly if it's going to result in the defendant getting out of jail?
It could, Judge. I think she's got no substantive history but for these charges.
Okay.
Judge, this is Sheena Hall before the court on 21 CF 821. You may have just a moment. You cool with this still?
Yes.
Judge Rui Harper on behalf of Ms. Hall. She's before the court on 21 CF 821. This is a violation of probation. At this time, she's going to withdraw her previously entered plea and enter a plea of admission. She'll be adjudicated guilty. Sentenced to 90 days in the Okaloosa County Jail, credit for time served to run concurrent. The state will stipulate to that credit. Ms. Hall served a significant amount of time in the Escambia County Jail, for which there was a hold, which is why the state's agreeing to this. Revoke and terminate her supervision and cost of judgment. Judge, these are misdemeanors, so there's no score sheet.
Thank you. State? State?
That's correct.
Okay. Ms. Hall, would you please raise your right hand? You swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So you heard your attorney state the terms of your plea agreement for this violation of probation. I see you've signed the back of the written plea agreement. Have you read this closely?
I have.
And have you gone over it in detail with your attorney, make sure you had all your legal questions answered?
I did.
And you understand that by doing this, you're waiving some valuable legal rights in order to get a final resolution.
I did.
Waiving the right to go to a trial and a hearing, etc. You
I understand all that.
You've gone over that with your attorney?
I did.
You're satisfied that
I
this is
am.
in your best interest?
Yes.
Based upon that, the court will accept your plea agreement here today. There'll be an adjudication of guilt, and the court, is this on the felony field? Are both of these misdemeanors?
Yes, sir.
So, are they on the 90 days on each of them? Each of the counts served concurrent?
Yes, sir.
Okay. So you're sentenced to 90 days in the county jail. For each of the two charges, they'll be served concurrent. They'll go at the same time. You're not going to get them stacked on top of one another. So it's a total of 90 days. You will get, the state stipulates credit. Okay, I lost you. I can't follow your writing.
Sorry.
If I could.
So the state stipulates credit. So in other words, stipulates that there's been 90 days credit already.
She served in excess of that.
She served in excess of 90 days, and so we're revoking and terminating supervision, and
Yes, Judge.
costs just go to judgment.
Yes, sir.
That's correct, Judge. My understanding was that before this, she had a hold that brought her over here, but before this, she had spent a substantial amount of time in a different county jail. So we're stipulating to that credit.
Very good. So stipulating to the credit for the full 90 days, and the remainder of the supervision and probation will be revoked and terminated. So basically, you're finished, except for the cost, they'll go to judgment. You want to give her, 6 months to pay the cost so that it might help her from.
The state would stipulate to that.
Ask for 6 months if
Yes,
possible.
why don't you do it? The reason for that, ma'am, it'll give you 6 months so you can pay for it, because if it goes to judgment, it might affect your driver's license.
Oh, that's fine, I don't got no driver's license.
So it doesn't matter, but.
Thank you.
But it'll.
I got you.
It'll go to judgment after 6 months if not paid.
Okay.
Okay, so you got 6 months.
Okay.
But this will allow you to get out today.
Thank you.
Okay. Very good. Thank you very much. Good luck.
Thank you.
Judge, number 9 on the docket is Lacey Hammett, but we resolved, and she was set for a bond hearing.
Right.
She was set for a bond hearing today, but her case was resolved yesterday, so that issue is moot.
Correct.
And then my last case is actually Janika Hales, number 11 on the docket.
And Judge,
This has got Mr. Gates being.
Yes, sir.
That's what we're going to try to clarify. Travis Gates from Ms. Hales in 23 CF 2757. This was a recent case. I think she was first appearance on December 13th. Our office was appointed. Unbeknownst to me, Mr. Harper had been incorporating this case in the cases he currently has.
Okay.
Given that, I'd ask the court to relieve the PD's office, allow Ms. Hales to proceed technically pro se, and then if Mr. Harper can resolve it, they can incorporate that into that plea.
Is that, are you anticipating that resolution to take place today?
No, Judge. The case that I have is set on the 21st. We set that
Okay.
a couple of days ago
Right.
because of the fact that she had just had first appearance on this matter, and so she got appointed the public defender.
Right.
I know what the offer is with respect to my case. This case is substantially similar. It might change a little bit, but it should be similar. She should be able to get out. The state, I think, still needs to file information, but we will resolve this on Thursday.
Is that the one you said you were going to file the information?
that's
yesterday?
correct, Judge.
Okay.
I need to sign the information, but
Okay.
I think we're going to be able to get this one resolved on Thursday. I have high hopes.
Okay. So court will relieve the public defender,
Thank you, Your Honor.
and we'll continue this case until Thursday, along with the other cases. Hopefully there'll be a final resolution of all the
We'll be
cases.
done. You got a little free trip today.
Rudy, do you need Willie King? Or is that-
Oh, yes,
Thank you,
Willie
Mr.
King as
Counsel.
well.
Thank you, guys.
Frank Barrett.
And then one matter, Judge, he is on the afternoon dockets, the 2:30 dockets, number 1, Willie King. Thank you. Judge, this is Mr. King before the court on 17 CF 3361, 18 CF 535, and 19 CF 1934. Judge, myself and the state have been in negotiations attempting to come to a resolution of this. I thought we had something, but Mr. King is not agreeable to those terms, which is his right. He is asking for an evidentiary hearing on this matter. So I would ask that we set this for an evidentiary hearing. I understand that we're going to have to coordinate that with your JA.
We're going to set it. And just for the record, don't negotiate anymore. We're going to a hearing on this and resolve it. We've come to this court, seems like a half dozen times, with a quote-unquote, a deal, and at the last minute, the deal breaks up. So let's go to a final, you have a right to a final, let's go to a hearing and resolve it. How about that?
That's correct, Your
So
Honor.
we'll,
Absolutely.
if you'll communicate with my office, how long do we anticipate needing for the?
I think maybe an hour, hour and a half, Mr. Harper?
That sounds sufficient, Judge.
Okay. If you would be so kind as to set that, get that set, and
Yes,
we'll
Your
do
Honor.
it as soon as we can.
I'll get that scheduled as soon as possible.
Okay, thank you.
Thank you, Judge.
So, just for, let's just say continued TBD, to be determined as far as the hearing.
I will request a hearing date starting today.
Thank you.
Thank you, Your Honor.
All right. Mr. Rare, I think you're up.
Perfect, thank you, Judge. Judge, all my cases have been in the Lupella firm. The first I've got is Daniel Simzak. Mr. Simzak is present and approaching, Your Honor. We have reached an early agreement with the state to resolve his case at 16 CF 2871 violation. Just of note, I'm about to approach the court, but there are 8 alleged violations in the affidavit we're going to resolve based on count 2 of the violation. The others would be dismissed, and I have an agreement. Can I approach?
Thank you. Would you announce the plea agreement, Mr. Rare?
Based on count 2 of the violation, it would be a withhold or maintain withhold of adjudication, modify supervision to add a $150 cost of prosecution and court cost, and 25 hours of community service work. He would have a buyout option at $10 an hour.
State?
That's correct, Judge. And Judge, I would say that this is a modification, so there's no score sheet.
Correct.
Thank you.
How do you pronounce your name again? Simzak?
Simzak, sir.
Mr. Simzak, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, you heard your attorney state the terms of the plea agreement. I see those same terms are contained in the written plea agreement that you've signed. Just want to make sure, have you read this closely?
Yes, sir.
And I assume you've gone over it in detail with your attorney?
Yes, sir.
And you understand that you're waiving some rights to go to a hearing in order to get a resolution? Obviously, this is a pretty straightforward resolution, so I understand. You're good with this, so you're entering this freely and voluntarily?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea agreement here today. The court will maintain the withhold of adjudication. There'll be a $150 cost, modified supervision to add 25 hours of community service. There'll be a $10 an hour buyout option. Very good. Thank you very much.
Thank you. Just check on probation before you leave, okay? And then last I've got, Judge, is Mr. James Aumont, A-U-M-O-N-T. Mr. Aumont is present and approaching, Judge. Judge, we're before the court on a motion for travel. Mr. Aumont was originally sentenced to 6 months of community control to be followed by 30 months of probation. As of fairly recently, he successfully completed his 6 months of community control with no violations. Mr. Aumont originally is from the state of Ohio, where most of his family still resides. He desires to travel to Ohio to see his family over the Christmas and New Year's holidays. He'd like to travel from December 23rd to January 6th and return to Florida on that date from his family in Ohio. As a condition of his supervision, which I believe is required by statute, is electronic monitoring, which I'm not aware of any issues or violations with that. My understanding is probation.
Sorry, say that again?
He's got electronic monitoring as a condition of his probation, so he's got that in effect right now, Judge. I'm not aware of any violations or issues that he's had with that.
Okay.
The reason we're coming before the court in lieu of a normal, travel permit request at probation and go through that procedure is my understanding, and I think the state may have their own statement on that, is they're concerned with the length of time he's out of state with the electronic monitoring and how that can be done appropriately and how to handle that. So we want to come first to address the court, if the court would grant him permission to travel to see family over the holidays, and 2, if there are any concerns from probation, maybe work out today how we can assuage the court's concerns and probation's concerns to make sure that he can comply with the electronic monitoring and still be able to go see family for the holidays.
Okay. Let me ask just a couple of questions, because this is actually doesn't come up that often. So it is, first of all, I'm gonna ask a legal question, and I'm assume the answer is yes to this, but I'm gonna ask it anyway. Does community control allow for out-of-state travel?
As of
That's
now,
my first question.
I think it can in very limited circumstances. However, here he's no longer on community control.
Oh, he's not on community control?
No, he's completed his 6 months as of a couple, 3 weeks ago. So now he's on his regular standard probation as of now.
Okay. Okay, so I know you can do out-of-state
Right.
on regular probation. What is the answer on the community control?
I think it's
just
very.
FYI, and it doesn't apply here, but I'm just for my own edification.
I do not know the answer to that question, Your Honor.
Well, that's all right. I'm glad I asked a hard question. I mean,
Yeah, I don't think there's a hard and fast rule saying no.
It does not come up very often. So, anyway, but go ahead. So, what is the state's position on this?
Your Honor, I did reach out to his community control or his probation officer, Ms. Howell, who is supervising him, and she indicated they do have concerns because he is required to be on the GPS monitor and for the length of the time that he's required to be, he's asking to be away. Because if there is any kind of an alert or alarm that goes off, he'll have to report immediately, which means he'd have to return immediately. That's the only way they can actually supervise him, is so that they can address any alerts or alarms. So that's their concern. They want the court to be aware of that.
Yes, Your Honor, I was just going to say, Officer Howell sent me an email yesterday right before work was over. She said that probation is not agreed with the motion to travel due to the issue with GPS monitoring.
Which was just outlined by the state. Mr. Rare, what's...
And again, Judge, now his mode of travel, where he's permitted to go to Ohio, would be via vehicle. I don't think flying is an option with the electronic monitor and the complications that would come with that. Via travel, he's able to stop, make trips, charge the battery, make sure he stays in contact with his charger so there's no violations in that regard. I have advised him that if there is some kind of like a low battery alert or something like that, he may be required to leave Ohio, return to Florida to check in. We're also honestly not sure with the electronic monitoring system if there is some creative way that he can still make a contact or video call with probation. If there is like a low battery alert or some minor innocuous thing like that would still permit him to travel out of state. Again, not dealt with fairly frequently with travel this distance, but obviously there's an alert, they'll be notified because you can still travel, I think, anywhere in the country and still be able to track and alert through the GPS monitoring system that's provided. So I guess we kind of defer to the court on that. If there's some creative way we can make sure that he can travel and then still be able to report on that.
My initial thought is how uncreative most of what we do. So that was my first thought, but that's not the answer. I mean, you're asking for something creative, but I don't know what that creative solution is. I appreciate the conceptually, but I mean, normally speaking, that you have to be able to return if there's something, the alert goes off.
Your Honor, normally the standard procedure is if there is an alert or alarm, they are required to immediately be able to be found and check in with probation.
What is immediate?
It's basically, the alarm company, they will reach out to them.
What if it was Montgomery? He was going to Montgomery and it went off. Would that immediate allow him to drive 2 or 3 hours? Is that immediate, or does this preclude any type of travel if you have a GPS monitor?
Your Honor, in speaking to Ms. Howell, they basically, they'll at least need to make verbal contact, and they do wish to make the visual contact, because if the unit is malfunctioning for any reason, they've got to be able to replace it, repair it, so they do require them to come in. So that there has to be the immediate contact so they know where they are, what's going on, and then they'll need to look at the equipment if there's any kind of a malfunction. So that's the concern. If someone's out of state.
How long would that be? That's what I've never dealt with this, and can probation, I mean, can you, I've never dealt with this, so I'm just kind of trying to figure out.
I'm reaching out to our high-risk specialist and our PPS to see what kind of input they can add, Your Honor, because I'm not familiar with that either.
Obviously, travel permits do happen with GPS monitors. I think the problem here is the distance between Florida and up there in southern Ohio, I believe where your family's at. And I think it's probably, 12 and a half hour drive at least, if you're making a straight shot.
About 14.
About 14 hours. So as far as what I mean by creative, nothing outrageous. As the state said, if there is an alert, let's say low battery or low charge, there's an alert to the system, they contact him and say, hey, what's going on? We need to maybe do a check. There has to be a verbal contact, so a phone call, so he has to be able to take a phone call, talk to them like you would anywhere in the country or locally to address the potential alert. Visual inspection, he can provide video or photographic evidence to show his monitor or what the issue is on that. If they require him to return, if the court gives an order that if you're allowed to go to Ohio and there is an alert that say you have to be back for a physical inspection of the unit for us to review that, you have 24 hours from the time they give you to get back to the state of Florida. It's a 14-hour drive. Even with a couple of stops, that does give him a window of time. Well, sorry, family, I've got to leave and go back to Florida. And that 24-hour window gives him time to get back here to comply with his requirements for the inspection. So that way, I think we can take care of everything if that restriction was in place.
See, that's the question I'm having. When, I mean, certainly a verbal contact, I got that, that's fine. The question is, getting physical contact, whether 24 hours is just, unacceptable, which means that you can't ever travel very far. I mean, it basically allows you to out-of-state travel, for 3 hours. I don't know what the magic number is of the contact.
Officer Howell got back to me on that. She said that he can check in by phone, but an immediate return has to be within 1 hour, Your Honor.
Within 1 hour? So you have to be within 1 hour. You can't leave within 1 hour. So he could travel up to Florala in Alabama, but not to Montgomery, Alabama.
As long as he's back here within 1 hour.
Well, yeah, I'm guessing how long it takes to get to Florala versus Montgomery.
Yes.
Montgomery is a couple hour person. So.
Judge, can I step back to speak with probation for just a moment? Can I step away from the podium for a moment?
Sure.
And Judge, I was just so the court's aware, I was reaching out to probation. An email was shot over to Ms. Howell. There's a written guideline or rule from the GPS company that provides the service that delineates what their timelines are, and there's a reason for that. I just asked if she has a copy of some kind of written format to send that to us. So I'm not sure if she has that or can get that to us, but that's what I was requesting. If there's some written guidelines from the company about what their check-in requirements are or something like that.
I think it's on them. I think they can make whatever requirements they want. I mean,
Right.
that's standard. I don't think, I'm not going to be forcing them to jump through specific hoops just to accommodate your client. I don't think, that doesn't seem to be appropriate myself. mean, I just think it's too much of an accommodation, 24 hours versus an hour. I mean, that's essentially what you're asking for. And the nature of the offense is failure to report. That is a significant determination.
Understood,
I'm
Your
going to have to
Honor.
abide by the probation. I'm going to support what their rules are. And they're saying the hour, I might, if it was 2 hours, 3 hours, I might be able to just say, look, it'd be unreasonable for you, but to say you've got 24 hours to come back, I don't think that is reasonable to force that on probation. So I'm going to deny it unless there can be something worked out.
Understood, Judge.
For that. I'm open to allowing the travel, but I don't.
If there's a more workable solution to make it happen.
If there can be
Understood.
a workable solution that probation will buy off on. And if you can accomplish that, you can get an order for me. You can do it without having to come to a hearing. We'll figure out how to do that.
We'll look into it, Judge, and see what we can get for the court. Thank you very much.
Thank you.
And that's all I have, Your Honor. Can I be excused?
Thank you. Have a good day.
You want to do your other?
Who do we want? Who wants to go?
Judge, I have a bond motion that we could do with Mr. Gates. It's Andrea Taylor. She's an inmate.
Hey, shut her again. You want to do that?
We can.
And Landon Maddox, attorney?
Mr. Medina is going to be handling those cases.
That's
Those were
in
all
the
added.
lady's office?
Yes, Your Honor.
I just wasn't familiar with it.
Your Honor, if I can approach with a bond order in Ms. Gibson's case, the state interviewed yesterday. This is the one we told before we were bringing this morning.
Okay.
The state had no objection to that order as written, Your Honor.
Very good, and that's in 23 CF 1906.
Yes, Your Honor, and I don't think we addressed the next court date either for Ms. Gibson. If we can set her for February the 12th.
Yes.
Thank you.
Make sure. Hold on a second.
Your Honor, this is Ms. Taylor before the court in a bond hearing. If I can have a second.
It was announced February 12th yesterday.
What's that?
It was announced yesterday to set her for February 12th.
Okay.
She knows that.
I'm sorry. Who is your client?
Your Honor, this is Andrea Taylor.
Okay, Andrea.
She was scheduled for a bond hearing this morning.
Sure. You may proceed.
Yes, Your Honor. I asked Ms. Taylor if she would like to address the court. She has stated that she'd like me just to proceed to argument, and I will incorporate what she would have said to argument, Your Honor.
Very good.
Your Honor, Ms. Taylor's before the court in violation of probation. Obviously, I know she's not entitled to a bond. We've had that conversation. The reason we're asking for a bond is we've had a bit of a change in her living circumstances. She's been in custody since roughly August. So,
150 days.
and she's gotten word from her family that her kids who are being supported by their neighbor, the neighbor is having trouble supporting the kids as well as paying for the bills associated with Miss Taylor's home. And it's basically said that if something doesn't change soon, the kids will end up in the custody of the department in Georgia. The sister has been trying to give the money as she can. Obviously, supporting a couple households is difficult. Ms. Taylor has asked the court to consider that and set a signature bond in her case. We've discussed that the court is inclined, pretrial services, GPS, whatever the court would need. I spoke with the sister and verified that information. I know Mr. Losco has also spoke with the sister and verified the information. I was hoping we could get a resolution in the case for time served to get her out. Unfortunately, it doesn't seem like that's going to happen, so we've had to move forward with a bond hearing.
And tell me the circumstances of the violation.
Yes, Your Honor. Part of the violation is that I'll have to explain it. Miss Taylor was on probation. She transferred her probation up to Georgia. During that time, she was allowed to have a travel permit. Probation ultimately was transferred. There were some issues with communication between herself and the Georgia probation office. At what point Georgia basically washed their hands and said, we're done with her. During that entire time, she had been in touch with Officer Howell. I have talked with Officer Howell about this. She did maintain contact with Ms. Howell, or Officer Howell, during that time frame. Explained to her that the probation wasn't coming to the house, they weren't showing up. My expectation is likely they were given the address, but they weren't coming to the right lot. I know that in this case, a letter was returned undeliverable at one point because it didn't have the right lot number on the letter. At a certain point, Ms. Taylor ended up with COVID, and at that point, a warrant was issued when she didn't come back, and here we are today.
Well, Judge, I'd lead with agreeing with the defense that she's not entitled to a bond.
We all agree on that.
Yes, Your Honor. I would say that regarding the affidavit, the allegations are that she absconded, and there's also some allegations of untruthfulness. Now, with regard to specifics, the underlying charge is a felon in possession of a firearm or ammunition. She was sentenced and did 2 months on probation before the VOP affidavit was filed, and then the warrant pended while they looked for her for several months, and then finally she was arrested, and now she's here. Judge, I would say that under these facts, I would say that it would be unwise to release her, given the fact that the reason for the violation is absconding and that she lives out of state. I would also point out to this court that probation has made it clear to the state that they're asking us not to put GPS monitors on anyone who is not a sex offender because there's a limited amount of the monitors. Also, I'm not sure if she even can have a monitor put on her so she can go out of state. I would defer to probation on that. With regard to what Mr. Gates said about me verifying information, I want to be clear with this court. I spoke with her sister, and her sister did appear to back up the story that the kids are staying with the neighbor, and then the sister sends money to the neighbor, but the neighbor is saying it's too great of a burden and they can't continue to be involved. But I wouldn't say that I verify these things. I would say that someone told me these things. I don't know that they are true. Judge, where we are is the state's opposed to the bond at this time based on the nature of the violations. I just don't believe that we can stipulate to a bond.
And Your Honor, if I can respond. I know the state mentioned the underlying charge is possession of firearm by convicted felon and or ammo. The specific facts of that is Ms. Taylor was in a vehicle with someone else. There was some concern about some, we'll say, drug activity at the time. During the course of the search of the vehicle, 5 rounds of ammunition were found in the trunk.
It wasn't a gun.
No firearm, just some ammunition in the trunk. That's what led to the charge. Subsequently to Ms. Taylor bonding out, there was an issue with the notice sent. The court has, we've all seen this where it comes back undeliverable. The notice for the next court date came back undeliverable. Ms. Taylor did not receive notice of that next court date. Subsequently, she was arrested on that FTA in custody, and at that point, Ms. Taylor chose to enter, was the court, I think yesterday said, some people like to enter pleas to get out of jail, and that's really what happened for her to get on probation, was either I take probation or I sit in jail longer. After that, Ms. Taylor, as I said, did maintain contact with Officer Howell. I was able to verify that. The issue, I think, really came down to some of the concerns with probation, and whether Georgia was actually doing what they were saying they were doing. As again, I can't verify that. I mean, as the state said earlier, I can only go based upon what I'm told. It's very hard to get a hold of any out-of-state probation officers, in my experience.
Yes, sir, I was working and they left the card on my fence and they were supposed to come back because they come to your house, but they didn't come back. They just left the card on my fence and didn't come in the fence or anything, and they were supposed to come back and they sent it back to Florida. But I talked to the Florida probation officer and I did stay in contact with her.
Let me ask you this, I'll give you a chance, let me just ask the question. Are you wanting to go back to Georgia?
Oh, yes, sir.
Okay.
My kids are there.
I understand that. Can we supervise out of Georgia? Probation? Can we supervise out of Georgia?
No, Your Honor, we'll just have to transfer probation out back to Georgia.
So they've already said they don't want it, right? And I just hear they kind of...
We can submit a subsequent request, but Georgia can deny it as often as they'd like.
So what do we do then?
She'll have to, if they deny her, she's just going to have to stay here in Florida, carrying out a probation sentence.
Judge, I would just point out, there's a lot of talk about this defendant having kept in touch with probation officer Howell. However, in the affidavit, and it's a signed affidavit by Officer Howell, she even said that she lost track of this defendant. The defendant's whereabouts were unknown at the time that she signed this, and that the officer had even gotten to the point where she was checking to see if this defendant was in some kind of jail or had warrants because she had completely lost her.
No, sir, I called her. I called her every weekend, even when the warrant was on, okay. But I did call her.
To that fact, Your Honor, she was not arrested on any charges. She was not sent to jail, so I don't think that would be an issue. As I said, I think part of the issue really is, again, this is where I was trying to get it resolved with a plea to some sort of time served to get her out of jail. That was the ultimate goal. Unfortunately, policies have come into place, and so the offer from Ms. Taylor was essentially 12-1 when she doesn't score DOC. And so it put me in a position, if we can't do that, then my fallback is to try and get her out on bond to see if I can't, at the very least, get her back to help take care of the kids, and then potentially look at,
arrangements for my kids.
at the very least, look at an evidentiary hearing or a sentencing, and then let the court make the decision at that point.
What are you requesting?
I would request a signature bond with pretrial services. I don't know the probation's position on GPS. I've never had that come up before. But I think we could do a signature with pretrial services, Your Honor. My expectation is that Ms. Taylor is likely going to enter an admission to the VOP and to be set out for a sentencing some point in January or February. We need to schedule that date at this point. My goal is obviously during that time frame, she can make the arrangements with the kids and get that taken care of. And if the court ultimately decides to either put her back in custody, she'd have those arrangements made. If not, and she's back on supervision, then she's got that taken care of as well.
How can probation supervise it? Can they supervise?
If we cannot transfer her over state lines through interstate compact, the best we can do is give her a travel permit for a set amount of time, at which point she'll have to return to her court into her probation.
And I think that's all, if she is on probation status right now, if she was to bond out, she still has to call in and report, correct?
No, she needs to come into our office to report it, and then we can try and work something out.
And, Your Honor, just to clarify sorry?
See, you get the last word.
Well, thank you, Judge. To clarify, what the defendant is asking you to do today is take a defendant who only successfully served 2 months of probation and then absconded for over a year before we could find and arrest her. Just let her out on bond, let her go home to her home state where the state does not want to supervise her, and we have no clear way of supervising her apart from trusting her to return back to our jurisdiction. That's what the defense is asking you to do, and the state is opposed.
Okay, he just said something that I was not clear on. You're saying that she was out of contact for a full year?
What I'm saying is that this warrant was outstanding for her for an entire year from the moment that the VOP warrant was signed and filed with the court, and it's all on benchmark, Judge, if you want to review it. It was signed and filed on August 12, 2022, and she was arrested in September of 2023, Judge. So what I am saying is that if she was in contact with her probation officer, why was this warrant pending for her arrest the entire time? I think that there are, and even if this court would like to reset this hearing for me to bring in the probation officer and we can take testimony from that probation officer, I'd be happy to provide the court with that testimony. But my point is, her story does not jive with the fact that there was a warrant out for her arrest from her probation officer, and it pended for an entire year before she could be arrested.
I asked her, and she said I would have to come before the judge.
I'm sorry.
Your Honor, once the warrant was outstanding, Ms. Taylor did speak with the probation about that. She was told she'd have to come back to the judge at that point. She was a sole provider, taking care of her family, trying to do what she could. I will say the September arrest date is when she was booked in the county jail. There's no way to know when she would have been arrested in Georgia because they would have had to transfer her back. We just know she popped up in our jail in September.
But my point, Judge, is at some point there was a decision that was made where she knew that there was a warrant out for her, and such a lengthy amount of time passed. I just believe it would be unwise for this court to let her go, trusting her to come back.
And I would simply say, Your Honor, sometimes difficult decisions have to be made. And I get that we would love for Ms. Taylor to turn herself in immediately. But again, I stress sometimes people make decisions based upon what they have. We could second guess them all day long. Ms. Taylor chose to work a job she had at Tyson Foods, which was about $20 an hour to try and support the family while she could. Now we're worried about that same family that's out there that's going to lose their home and potentially end up in custody of Georgia DCF.
And as long as I have a date and I know when to come back, I'll come back. But the notice got sent back was the issue. And then once Georgia sent the probation back to Florida, okay.
You said you were doing what, as far as where you...
The conversation with Ms. Taylor... The conversation with Ms. Taylor was, Your Honor, and I specifically said, look, let's look past bond. We don't know what's going to happen with that. What are we doing with the case? And Ms. Taylor decided that she would prefer to admit the violation and set it out for a sentencing. Concern, obviously, is that won't potentially be until end of January, maybe February later, and that leaves the issue with her children. As she stated, if the court was to give her a court date, she will come back. I think the big concern really is trying to make the arrangements to handle the kids in case she does end up with a 1129 or a 12-1.
How long of a hearing do you anticipate that being?
I think with the sentencing, less than 30 minutes, if that. It'd mainly be argument. Ms. Taylor might make a statement to the court.
Sir, I've already got 150 days in. Okay.
As a matter of fact, the plea agreement for plea straight up is sitting on the printer downstairs. I intended, after the bond hearing, to have Ms. Taylor sign that, submit it to the court, and then set it for a sentencing.
If that admission of violation gets dealt with today, let's go to a sentencing on Thursday. Let's get in there and let's argue this case and get a final resolution.
My issue is
I'm
not available on Thursday, Your Honor. I have an appointment. That's the only hiccup.
I'm going to reserve on this for right now.
Yes, Your Honor.
Just hold her here for a little bit.
Yes, Your Honor. I was going to hold her anyway to go over the plea agreement with Ms. Taylor anyway.
Court will reserve.
All right.
I mean, I'll plan on making a ruling today, but.
Yes, Chairman.
Your Honor, I have one out of custody, is that okay?
Yes, sir.
Zachary Zachary L. Dispinet. Mr. Dispinet is number 23 on the morning docket, 22 CF 745. I don't know if the state has had an opportunity to evaluate an offer in his case. We could go ahead and just simply deny it and set it off. He could look into drug court, but he wanted to see what the state's offer would be before he made a decision on drug court, because that's a serious commitment.
State?
Sorry, Your Honor, give me just a second.
It's not a problem for us to deny it and set it off. It was mostly about whether he needed to be talking to Terry Henderson with drug court.
Your Honor, the state's offer is 12 months and 1 day in the Department of Corrections.
Your Honor, at this time, Mr. Dispinet will deny the VOP. Rather than put it on for an evidentiary hearing, if we can just get a control date, and then he'll decide whether he wants to talk to Terry Henderson with drug court on the second floor, set up an appointment with her to have that option. And if we could just continue this for a non-evidentiary date, is it January 18, Your Honor?
Yes, we'll continue this till January 18th. One thing I would do is to ask, go ahead, if you want to inquire about drug court, try and get that done before the 18th.
Yes, sir.
You should be able to do that, shouldn't be a problem, but go ahead and get that done so we can kind of figure out what's going on the 18th.
I'll go talk to her right now.
Okay, thank you.
Thank you, Your Honor. Okay. Yes, sir. Your Honor, my others are, that are present are all inmates.
Okay.
And I should be ready to proceed on my inmates. Okay, we are working on a couple, I may have some information that just came over from the state. May I have just a moment with Ms. Sharples?
You want to go ahead, why don't we take our morning break? And we'll
I
come
think
back
that'd
and
be
then
great,
we'll
Your Honor. We're trying to get a couple of more deals that will get people out of jail.
If
Or at least
you
I
can
can.
just text me when they're ready to come back.
Yes, sir.
All rise, please. We're recess.
To fit any need. Visit our store in Crestview or online at DaceTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with? I think I was bit by a vampire. This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. CNC Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview very own Dixie Dan Powell of Powell Injury Law for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with? I think I was bit by a vampire. This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalwear. We're located at 648 North Wilson Street. Call 850-682-2446. CNC Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Where I Press Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Mr. Gates, Mr. Medina, who wants to go?
I left a message. Okay. Go ahead.
You know, I think we were going to recall Miss Andrea Taylor.
You want to pick up your phone?
It's okay.
We're back in session already for Andrea Taylor.
Because I was personally.
Your Honor, after speaking with Taylor, we have a plea agreement we're going to file. As I mentioned during the bond hearing, Ms. Taylor and I discussed ultimate goal after bond. After speaking with her, she's decided to admit the violation and plead to the court. There's going to be no cap on incarceration or supervision.
Okay, Ms. Taylor, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So I'm looking at the plea and sentencing agreement. It's straightforward. They're previously adjudicated guilty on the counts, so you're pleading to the court, admitting the VOP violation, and basically leave it in the discretion of the court as to sentencing. Is that what you want to do? So there's no limitation on this, on the cap or the incorporation. You're going to get a chance to argue it, you know, whether or not what you should or shouldn't do. And there is a large maximum incarceration. You just want you to be aware of it. You understand that? Yes?
Yes, sir.
You've talked about this. Your attorney said you've talked about it probably significantly, but I want to make sure you had all your legal questions answered by your attorney.
Yes, sir.
Okay. Court will accept your plea. The state's in agreement.
That's correct.
I don't know that they can even object on this one.
And Your Honor, the score sheet the state filed shows 41.2 points. So the I guess the way I would explain, the starting point is not a non-DOC sentence. It's discretionary at this point.
Are you wanting to Are we prepared to proceed forward with this sentencing today?
No, Your Honor.
Why not?
Well, because I didn't know she was going to plead today, Judge.
It doesn't matter. I'm just asking, what do you got to do? You make arguments, you're going to bring somebody in?
I'd like to speak with the probation officer. My plan was to bring the probation officer in. Because what's going to happen if we proceed to sentencing today is she's going to say that she's been talking with that probation officer, and I don't really have a probation officer to be able to contest that. And at heart of the violations, which she's already admitted to, was that she was being untruthful.
Why don't you see if you can get a hold of the probation officer?
Yes, Your Honor.
We'll look at it. We'll look at it this afternoon and see if we can bring it back.
Yes, Your Honor. And I know that would be Ms. Taylor's preference.
Yes, sir.
And just so the state's aware, we have admitted to all the violations as stated in the VOP affidavit, so it wouldn't do as much at this point to say that it's incorrect.
Repeat that again?
It wouldn't do us much good at this point to now come back and deny the allegations in the VOP affidavit at a sentencing, considering we've already admitted to those, Your Honor.
Right. And my point is I don't know what she's going to say.
Okay.
Pretty much what I've told the court at the bond hearing.
Okay. Well, let's see if we can try and.
Yes, Your Honor. All right.
Okay, thank you. Can you leave us here?
That should be.
Thank you.
Your Honor, I can, well, Mr. Medina is.
I'm ready to go now.
Did you get a hold of?
Well, whoever's coming into the queue, we can take, whatever.
I don't know if they got anybody else.
All right, thanks.
While they're getting that lined up, Your Honor, I will see, I think there was Lance Hines on the docket still. We took care of that case yesterday. That should be number 12 on my docket.
Correct.
And then, I think that was all that I had before the court this morning.
Okay.
And then on the afternoon docket, there was number 10, Dean Fearson.
On the plea docket?
Yes, Your
Honor. Arraignment.
He entered a plea last week, so we've handled that case.
He entered a not guilty.
No, Your Honor, he entered a plea to supervision last week.
That's right.
And my other ones have all entered not guilty pleas, so I'll be back in case we get appointed someone else this afternoon.
All these this afternoon?
Mr. Freeman, Mr. Johnson, and Ms. Knight, I filed written pleas and not guilties yesterday.
Do you have Jessica Knight?
Also a not guilty plea yesterday, Your Honor.
Yeah, you don't have many this afternoon.
There are two unrepresented, Mr. Humphreys and Mr. Jordan, but I was going to come back and see if the court was going to appoint me to. Plus, now we have Ms. Taylor coming back.
Is Freeman was a
Not guilty plea, yes,
not
Your Honor.
guilty? And then you've got Humphreys, like you say. What about Timothy Johnson?
Not guilty plea.
And you got Humphreys, you're right, Humphreys and,
Jordan are unrepresented, so I'll come back and see if the court's going to appoint us.
okay, very good.
I'll be back this afternoon, Your Honor.
Thank you all.
Your Honor, Steve Medina with Keely Annon, A-N-N-O-N, number 15 on the morning docket, 22 CF 2733. We have a misdemeanor-related violation of probation agreement that's also going to deal with a underlying petty theft charge that triggered the VOP. May I approach, Your Honor?
You may. Thank you. Thank you.
Your Honor.
Would you announce the plea?
Yes, Your Honor. And this was, my understanding is she's been going to JCS, Judicial Correction Services, not state probation on this one. In 22 CF 2733, she will be admitting the VOP. And Madam Clerk, this agreement also resolves 23 MM 3672. And she has court scheduled in that for tomorrow, misdemeanor court, and this will moot the need for that court appearance tomorrow. And my understanding is she would be released from jail today based on this agreement, assuming this court accepts it. Admit the VOP, reinstate and modify the existing supervision in 22 CF 2733 to add shoplifter awareness course, no trespass at Target at, I believe it's 252 East Miracle Street, Strip Parkway, Mary Esther, Florida. Restitution of $149.15 to Target. 24 hours community service, $100 VOP fee, $100 PD fees. She would be adjudicated guilty in 22 MM 3672 as charged. She would have a time served sentence, $270 in court costs, $50 in public defender fees, and those monetary obligations would be transferred to 22 CF 2733, in which I already announced there are also non-monetary obligations that would ordinarily go with a petty theft that are going to be added to 22 CF 2733 supervision.
Very good. You pronounce it Anand?
Annan.
Annan. Ms. Annan, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
State, is an agreement, yes?
That's the state's agreement.
Okay. And there's no need for a score sheet because it's a misdemeanor, right?
That's correct, Your Honor.
Okay. Ms. Annan, you heard your attorney state the terms of the plea agreement, and you have not signed the plea agreement.
Oh, I apologize.
That's all right.
I didn't have a pen, sorry.
That's all right. No, I always look for it, you know, and normally it's...
Thank you, Judge.
It's all right.
Can I have till tomorrow to report? Oh, sorry.
I got to ask you a few questions.
Sure.
Your sign. Your Honor, I signed in the wrong spot. She then signed in the right spot. So got two signatures.
It's been a long week, hasn't it, Mr. Medina?
A long week and a half.
That's true.
It keeps on giving.
Ms. Annan, you heard your attorney state the terms of the plea agreement, and I can see now you've signed the plea agreement. Just want to make sure, have you read this closely and gone over it with your attorney?
Yes, sir.
You understand that by entering into this will be a final resolution of both the petty theft, the misdemeanor charge, as well as the violation of probation.
Yes, sir.
All those will be resolved here today.
Okay.
And you believe that's in your best interest?
Yes.
Okay. And you're doing this freely and voluntarily?
Yes.
Okay. Based upon that, the court will accept the admission of the violation of probation, will reinstate and modify on the 22 CF 2733 adult shoplifter awareness course, and also requirement to have no contact with Target at Target on Miracle Strip Parkway in Mary Esther, and then restitution and fees payable during the course of the probation, 24 hours community service. You'll be an adjudication of guilt on the misdemeanor charge as charged, and you'll be sentenced to credit for time, time served, so you're done with that. Other than the fees and costs, they'll go to the other probation, so you'll have that amount of time during the course of the probation to pay those. Question?
Yeah.
Sure.
Reinstatement, do I start the year over or do I pick up where I left off?
I don't think there's anything under this agreement that would extend her probation term.
That's
Your Honor.
correct. So reinstate means to reinstate to what it was.
Okay.
So, and then it modifies it, not to add any more time, but it modifies it to add additional requirements.
Okay.
And of course, more fees and costs.
Your Honor, she had let out a little over a year ago, June 14th, 2023, so she probably has roughly half a year left.
Okay. So, yes, that's a good question, but that's one I can give you a definitive answer on. So,
Also, can I have till tomorrow morning to report to probation because I have to catch the bus from Crestview, depending on what time the jail lets me out?
yeah, I mean, if you can't get to it, that would be reasonable. If you're saying you can't get the bus down by that time?
Yeah, if I can't get back to Fort Walton in time because the probation office there closes at 3, if I can report there tomorrow morning, that's the only thing I ask.
I don't think the probation officer doesn't close at 3, but.
Well,
they do have strange hours, Your Honor.
They really do.
I've tried to get in contact with them a few times, have been unsuccessful.
Yes, you can wait until tomorrow.
Okay.
Tomorrow morning. Thank you.
Report first thing in the morning. It's at JCS.
On Industrial, correct?
Does the bailiff have a card? I don't know the address. Is it Industrial?
It's 10 Industrial Street.
Okay.
Yes, ma'am.
I'll give you a call.
I don't need one. That's okay.
Thank you, sir.
Okay. Good luck,
Thank you.
ma'am.
Thank you, ma'am. Good luck.
Yes, sir.
Sarah Benny.
Your Honor, next up is docket number 18, Sarah Benning and 23 CF 2244. This is a competency hearing, Your Honor. There is a competency report that was provided, and I do not think that state objects to the finding of incompetency. Then there's going to be a need for a continuance so that we can get with John Barnes and see what type of options there might be for outpatient services, because it is not a Florida State Hospital commitment recommendation, which is good in the way that it's possible that outpatient services can be found that would allow her to be restored without going to the hospital.
So the state's in agreement as to finding incompetency.
That's correct.
The court makes the finding, and the defendant not competent. You want to come back? How long do we need to go to explore these things?
I don't think it's going to take long to get some input from Mr. Barnes. So I would say
16th? January 16th?
January 16th, Your Honor.
Okay. So we'll come back on January 16th to determine kind of where we're going with it.
January 16 at 9 a.m.
Correct.
Thank you,
That
Your
would
Honor.
be for a status.
Yes, Your Honor. Her dad is here, so he understands then what the status is.
Okay. Appreciate your help, sir.
If we can
Okay.
recognize an appropriate state agency and the district court attorney.
Okay.
We don't have an appropriate state agency within the right as far as a CRC.
Thank you, Ms. Benning. Thank you, Your Honor.
As far as an S.
All
Don't be
right,
necessarily
thank you.
spending your time and how it's dividing higher councils.
I'm sorry?
Have you excused?
You may.
Thank
you. As long as you don't have anything else to do here.
Not until 1:30.
You may.
Thank you.
Don't forget you.
Your Honor, can we pass Ms. Cooper for a few minutes?
Sure.
And also, just step back. You're going to step back for a few minutes. We're trying to work something out.
Okay.
Also, is there any way we could pull John Ewing out of order? John Ewing, to allow Ms. Basso to plead that out? Sorry about
Sure.
that. You can email me, but I can't give you an update because she's not competent to give me permission to give you information. So I can only give you what's on that court record. But you can give me information, sure. You can set an appointment with my assistant to give me information, but I can't give you information.
Want to help with that?
Would you please announce the case, Mr. Medina?
Steve Medina with John Jacob Ewing, Your Honor.
22 CF 2460. Is that correct?
Yes, it is, Your Honor.
Okay.
He is signing his agreement.
And Your Honor, the state did file an amended information late yesterday. Does the court have that?
I did not see that.
Your Honor, would you just like a copy to refer to? I believe Madam
Sure.
Clerk has one. May I approach?
You may. Thank you. Okay, thank you.
The score sheet will reflect that particular information.
Okay, very good.
It's an extra copy for you. Your Honor, I'm providing a probation a copy. Sorry. May I approach with the agreement and score sheet?
You may. Thank you. Is the defense okay with the score sheet?
Yes, Your Honor.
Is this a downward departure?
It is not, Your Honor.
Okay, thank you. Would you please announce the plea agreement, Mr. Medina?
Yes, Your Honor. Under the terms of an agreement reached with the state on the third amended information, defendant would be adjudicated guilty as charged. On count 1, there would be 5 years DOC. On count 2, there would be 3 years DOC, followed by 2 years probation. And that 3 years DOC is consecutive to count 1 DOC of the 5 years. So it's a total of 8 years DOC with credit for all time served between counts 1 and count 2. And as I stated, the third year increment related to count 2 will be followed by 2 years probation on count 2. Thereafter, there will be on count 3, 5 years probation consecutive to counts 1 and 2. And thereafter, there will be on count 4, 5 years probation consecutive to counts 1, 2, and 3. So that totals 12 years between counts 2, 3, and 4 of probation. And in addition, there will be no unsupervised contact with children other than defendant's own biological children, $615 court costs, and $150 public defender fees, Your Honor.
That is the state's agreement, Your Honor, and it was structured that way because they're all third-degree felonies.
So, just point of clarification, on count 2, where you have 3 years DOC followed by 2 years probation, that's consecutive to 1. It's just, I just don't know how the way it's phrased, how it works. So would that, if you didn't have count 3 and 4, just exclude those for just a second. Counts 1 and 2 would be a total of
8 years DOC.
Yes, total of 8 years DOC.
And 2 years probation if you don't go any further, correct?
And 2 years probation. Okay, so this is what we're talking about here, is total of 8 years DOC.
And 12 years
And
probation.
12 years probation.
Yes, sir.
Okay, that's when you add.
That is the agreement, Your Honor.
Okay, very good.
It had to be structured in
That's
this
fine.
way to be compliant with the statutory limitations.
I understand. Mr. Yu, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state the terms of the plea agreement, and those terms are contained in the written plea and sentencing agreement that you signed. And I just was going over clarifying and want to make sure you understand it. So, I mean, to summarize it, it's a total of 8 years DOC with credit for time served plus 12 years probation.
Yes, sir.
You understand? Your understanding of kind of the core of the plea agreement?
Yes, sir, I do.
Okay. And you understand that by entering into this plea agreement here today, You're giving up some valuable legal rights, the right to contest these charges, force the state to prove their case beyond a reasonable doubt. You're waiving the right to force them to do that.
Yes, sir.
So that you can have a final resolution of this case here today.
Yes,
Is
sir.
that what you want to do?
Yes, sir.
You believe that's in your best interest to do that?
Yes, sir.
And you have had all of your legal questions answered by your attorney?
Yes, sir.
Are you satisfied with your legal representation?
Yes, sir.
And you're entering into this freely and voluntarily?
Yes, sir.
Nobody threatened or coerced you to get you to enter into this?
No, sir.
Is there a factual basis?
Yes,
for
Your
the entry
Honor.
of this plea?
Yes, Your Honor.
And DNA evidence would really come into play?
That's correct, Your Honor. There's no DNA evidence.
That's correct, Your Honor.
Very good. Based upon that testimony, the court will accept your plea agreement, and there'll be an adjudication of guilt as to all
That's adjudication of guilt as charged on all 5 counts.
Hold on. You've got 5 charges, but you only have your plea agreement as to 4 counts.
That include count 5?
Your Honor, that was a typo. May I basically...
Here you go.
Where it says counts 4, that should have said count 4 and 5. Let me make sure on that, Judge.
Yeah,
Sorry.
oh, that's all right. We just want to make sure. The whole purpose of my questions is, you know, a lot of times it looks like what we do is kind of rote stuff. This is a good example. 2 things you need to, from your point of view, 2 things that have to happen today. 1, you need to understand exactly what you're pleading to.
Yes, sir.
Okay? We're not trying to trick you, surprise you. I mean, you got to know. And a lot of times the devil's in the details. And I want to make sure you're doing it freely and voluntarily. Those are the twin towers of my question from your point of view, from what you need to do.
Your Honor, I want to change it on his page as well and on probations to make sure everybody's on board as to the clarification. I apologize for missing that.
I'm glad I caught it.
Just showing.
Yes. Thank you.
So, Your Honor, I clarified it would be counts 4 and 5 that would be subject to 5 years probation consecutive to counts 1, 2, and 3. That would be concurrent between 4 and 5, but consecutive to the preceding probations on count 1, 2, and 3.
So it's still the total that we laid out of 8 years of DOC followed by 12 years of probation is what was agreed to.
Yes, Your Honor.
Okay. And I hate to do this, Mr. Medina, but I need you to clarify that counts 4 and 5 are concurrent between each other because it's not clear on this.
Yes, Your Honor.
Just put concurrent right after that, concurrent with each other, 4 and 5, concurrent with each other. Question?
Yes, Your Honor. Is this going to be sex offender probation or
No.
probation?
Standard?
Standard.
Yes, sir.
Thank you for the question. That's a good question.
Yes, sir.
Thank you.
Okay, thank you. Okay. So again, we're going to go through it just so we're clear. You've got 5 counts on the information. That's your charging document. Count 1, you're receiving 5 years. You're sentenced to 5 years DOC.
Yes, sir.
Count 2, you're sentenced to 3 years of DOC, followed by 2 years of probation. That's consecutive.
Yes, sir.
You're stacked on top of each other to count 1. Count 3 is 5 years of probation, And that's consecutive to counts 1 and 2. So that's an additional 5 years of probation. So it's 2 plus 5. And then counts 4 and 5 are 5 years of probation that are consecutive to counts 1, 2, and 3, but they're concurrent with each other. So it's a total of 12 years probation after the 8 years, after the 8 years DOC. You will get credit for all time served. And then you have the additional requirement, no unsupervised contact with children other than your own biological children, and then the court cost and fees. Okay. Any questions concerning it?
No, sir.
Your Honor, just for the record, it's going to be a long time, but when Mr. Ewing gets out, he will need to report to state probation in Fort Walton Beach to commence his probation. So, thank you.
Yes, sir. Thank you.
Mr. Ewing is my last case. May I be excused?
You may. Now, you've already filed the new information, so that's just super extra, right? This was extra.
I'll take it back, Your Honor. That was actually my copy.
Okay.
Who is this, Mr. Mayor? Just want to be sure you had one.
I was just going to dispose of it, so I. Who is this, Mr. Medina?
Mr. Bethune.
Steve Medina with Reginald L. Bethune, 23 CF 2580, 23 CF 2581, and 23 CF 2582. Does the state have an offer, a global offer to Mr. Bethune before we proceed on a bond hearing?
At this time, Your Honor, the state's offer is going to be a DOC sentence.
Okay. Your Honor, for purposes of this afternoon on the 1:30 docket, Mr. Reginald Bethune is docket number 1. In those 3 cases, he can go ahead and enter a not guilty plea and take him off the 1:30 docket.
Very good. It'll be not guilty, and we'll come back on 2/14.
Yes, Your Honor. Depending on the outcome of the bond hearing, if we may proceed with the motion for bond reduction. Mr. Bethune currently has a $27,500 total bond. He's not able to make a cash or professional bond. He's asking for a signature bond. He represents that he's self-employed and has never failed to appear. I would ask that he be sworn so that I can ask him a few questions, Your Honor.
Mr. Bethune, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Mr. Bethune, without talking about the facts of any of your cases or the charges in any of your cases, if you do get a signature bond, will you come to court as required?
Yes, sir.
Okay. Have you ever had a failure to appear for a court appearance?
Yes, sir.
And how old are you?
61.
Okay. And if the court were to require pretrial services while you're out on bond, hopefully signature bond, would you maintain regular contact with pretrial services while you were out on bond?
Yes, sir.
Okay. I don't have anything further, Your Honor. I'm sorry, Your Judge. May I ask one more question? Is there anything more you wanted to tell the court, advise the court of that I haven't asked you about without talking about your cases? Anything else you wanted to say to the court?
Well, I'm born and raised in Fort Walton. I've been here all my life and living with my parents and stuff. My girlfriend, she was going to be here today to find out what was going on. Me and her been together like 15 years, and she's from Fort Walton also.
Okay. Anything else?
If I was to get, signature bond like that, I don't miss no court days or nothing like that.
Okay.
But I never missed a court day. I always appeared to my court days.
Yes, sir. Nothing further, Your Honor. Thank you.
Your Honor, the victims in this case could not be here today. I did make contact with them and did comply with Marcy's law and let them know that this bond hearing was occurring today. Your Honor, one of these victims had her house burglarized twice. This is the subject of 23 CF 2581 and 23 CF 2582. Mr. Bethune burglarized her house twice on 2 different dates in June. So that the victim in that case is scared to be in his very presence. Her personal safety and security at her own home has been violated. The state and the victims of both of these, of all 3 of these offenses, do oppose Mr. Bethune getting a bond. I anticipate that Mr. Bethune is going to qualify for habitual felony offender designation. The state's offer will be Department of Corrections in this case. The bond, or more importantly for the purpose of a bond hearing, the bonds that are set are appropriate. In Mr. Medina's recitation of the total amount of bond that the court said at first appearance is correct, but the highest bond is $10,000 on that armed burglary, Your Honor. The rest are $2,500 cash or professional or $5,000 cash or professional. All the bonds that have been set are appropriate, and the state and the victims would oppose the bonds being reduced.
Your Honor, may I ask one question, for a point of clarification? We went ahead and waived arraignment and pled not guilty. In that last statement, Ms. Sharpless stated that there was a armed charge of burglary of armed, and I see that was on the first appearance paperwork, but I do not have benefit of the information. Is one of the information stating an armed reference, or was that just an artifact of first appearance?
That's correct. The state's alleging that he was armed with a dangerous weapon during the commission of one of the burglaries of a dwelling.
And that's 23 CF 2580.
That's correct, Your Honor.
May I have your indulgence for one moment?
How was the defendant alleged to have been armed?
Your Honor, that's what I was looking at.
I'm asking the state that.
Okay.
I mean, you can answer it.
So Your Honor, the facts of the case, as I understand it, is there was a house across the street where Mr. Bethune may have been living. It's a construction site. There was a crowbar there. It's from my understanding that he took a crowbar from that construction site. That's how he broke into the home, and the crowbar can be used as a deadly weapon, Your Honor. So that is the dangerous weapon.
Your Honor, I just would respond. That's what I wanted to check, because a crowbar could be used in such a way, but there's no statement that I can see in the facts that it actually was intended to be used in such a way. Based on the allegation, it was used to enter the rear door of the residence. It wasn't used in any kind of a threatening way. I would ask that to be taken into consideration.
Was the dwelling occupied?
At the time, Your Honor, no, the victim was not at the residence on the first date. But again, I think it's important to note that after he broke into the back door with a crowbar, he is alleged to have come back on a different date the next week and broken a window to get into the victim's residence a second time.
Okay. Anything else, Mr.
Nothing further, Your Honor.
Well, the totals of the bonds are pretty stout. But the individual bonds that are set forth are, in the court's view, very reasonable. And the only reason the totals are great is because you have 5 separate counts, 3 of which are burglaries, and as well as grand theft and criminal mischief. So I do believe, and I haven't heard any change of circumstance, so the court finds no basis for a reduction in the bond. The court's going to deny the bond request, bond reduction.
Your Honor, excuse me.
Right this way, Mr.
Thank you, Your Honor. Your Honor, he would remain on February 14th.
Larry Brown?
Pre-trial.
Correct. February 14th.
This way, sir.
Your Honor, this is Larry Brown, right? Your Honor, Steve Medina with Larry Brown, docket number 2023 CF 1356. Your Honor, does the state have an offer for Mr. Brown at this time?
Give me just a second.
Thank you.
I thought I sent you. Sorry, Your Honor, I now have to pull up the offer sheet that I believe I already sent.
Your Honor, I believe that there's a representation by Maria Johnson in the violation report dated October 24, 23, that it was a recommendation for to be evaluated for Phoenix House. I don't know if that helps the state.
Your Honor, the state's offer in this case was 12 months and 1 day in the Department of Corrections.
Your Honor, based on that recommendation, there's no basis for reaching an agreement today. Mr. Brown will deny the violation, and I will be...
No.
Your Honor, I'm certainly recommending that he not speak to the court and that he allow the denial to be entered. He may be under the mistaken assumption that he can enter a negotiation in open court and get a better outcome than the state's offer of 12-1. I don't think the state will do that, and I don't think the court will enter the negotiations. So I'm certainly advising that he not address the court himself.
Can I speak, Your Honor?
Raise your right hand. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
You may speak.
I got my father is on hospice right now, and I'm trying to get all this squashed as soon as possible. I was going to ask for some county time. I've already got like almost 4 months in, and I don't score out to prison. I don't know why they asked for 12-1. Her first offer before I took this was 11-29. I don't know how that works, but I don't even score out to prison, Your Honor. Okay. I was just trying to get this squashed so I could go spend some time with my father before he passes away. I don't know. I really want to get all this knocked out today, you know, wasting course time, wasting my time, respectfully, just trying to get it out of the way. And
well, let me tell you how this works. Okay. You got a plea negotiation between two parties. You, through your attorney, you and your attorney, and the state. Okay. State's made their offer. I don't get in the middle of these negotiations.
All
You
right.
want to plea up to the court? Straight admission? That's your prerogative. Then I would come into play. But it also leaves you open for more than even what the state requested.
Okay.
I mean, I understand everybody wants these things dealt with.
Yeah.
And we can all agree that this is a slow process. So.
And Your Honor, I just wanted Mr. Brown to be clear on the record too, is that even if he were to enter an admission and the court were to accept that admission, the normal mode of proceeding would be the court would ask for a specially set sentencing hearing, so he probably wouldn't be sentenced today anyway.
That's correct.
So I've entered a denial for Mr. Brown. Unless he has something further, I would ask it to be set on, I think, January 18, 9 a.m. for a VOP without subpoenas, so we can see if things can be worked out. In the meantime, I'm certainly recommending that he get a Phoenix House evaluation.
We'll come back on 118.
At this minute, Mr. Brown.
Without subpoenas at 9 a.m.
Just wait, Mr. Brown.
John Chapman.
Your Honor, Steve Medina with John L. Chapman. Mr. Chapman's case is Docket 2123 CF 914. With him in the audience once again is his brother, who's always very supportive of him. At this time, we're here on a competency hearing. The state, I do not believe, objects to the, based on the competency report, a finding of not competent to proceed. The complexity would then be, we would need to work with John Barnes to see if we can get a good option. If the court does find him to be incompetent, we'll have to work with Mr. Barnes to see if there is an outpatient alternative. There is not a recommendation to send him to Florida State Hospital, so maybe we can find a way locally to restore him. And I think January would be enough time to work with Mr. Barnes, hopefully. I'm not sure the date, Your Honor.
Let's come back on the first miscellaneous docket, January 16th at 9 a.m.
Does the state want to state its position on the competency, and the court would probably need to make that clear?
I agree, thank you. Is the state in agreement?
Yes, Your Honor. The
Based
state,
upon the agreement, the court will order the defendant deemed incompetent, not competent to proceed.
the state has read the report, received the report, would stipulate to the report and its findings, Your Honor.
Very good.
We do need to get with Mr. Barnes about how do we best do not Florida State Hospital treatment. So it would be best if we went to
Very good.
I'm sorry, is that January 16th?
16th.
Thank you.
9 a.m.
Thank you, Your Honor.
This way. Preston Davis.
Thank you for being here, sir.
Thank you, Your Honor. Your Honor, approaching is Preston Davis. He's approaching very slowly because of a medical condition that I'm not going to go into on the record, but I don't believe he's incapable of doing the plea, but I'm going to make clear that on the record. But he's before the court, docket number 14. That's a list of I think 7 misdemeanor cases, and then there's also the criminal felony VOP, that's docket number 22. So I'll begin with that. That's 23 CF 199. He's also before the court in some misdemeanor cases that are going to be run in a global plea agreement, 23 mm 798, 23 mm 800, 23 mm 801, 23 mm 803, 23 mm 804, 23 mm 806, 23 mm 809, and I am switching first pages because there was a clarification of a couple of things that I need to make sure he's aware of that don't change the context, Your Honor, but may I approach with the agreement? Which, approaching, Your Honor, and this is without a score sheet because it is going to be a reinstatement and modification on the probation. May I?
May.
And there is no new felony. There were new misdemeanors that are going to be handled. I'm going to provide a copy to him as well as probation, Your Honor.
Very good.
This one? Yeah. Your Honor, just with a little bit of background, thank you. Sorry, man. Mr. Davis, just to be clear, you're having a medical condition, but does that affect your ability to adversely affect your ability to understand what you're doing here today?
No, it's not affecting mine.
Okay.
No, it's
Okay. Your Honor, under this agreement, Mr. Preston Davis will be resolving the VOP in 23 CF 199. It's a little bit complicated because there were 7 worthless check cases that were before he pled out his felony cases under, I think it was a deferred prosecution, but basically they were being, there was a diversion program in misdemeanor court that preceded his felony plea. For whatever reason, he didn't complete the payment, and so there was a court appearance scheduled that he didn't get notice of apparently in misdemeanor court. So that's being resolved with the state agreeing as part of this global agreement not to pursue that FTA. That FTA was the sole basis for this felony VOP. So this VOP would be dismissed as such, but still be a reinstatement and modification to deal with the whole situation globally, so he no longer has any court appearance on the misdemeanor cases. So I will now proceed with the agreement, Your Honor.
Very good, thank you.
There will be an adjudication of guilt in basically 2 of the 7 worthless check cases. The way misdemeanor, the state does it there is they allow for grouping by bingo parlor, basically, of the restitution so that the individual only has 2 cases with cost of prosecution in 2 cases and PD fees in 2 cases instead of in multiple cases. By the way, though, I think there might be an error on the cost of prosecution. I think the misdemeanor court cost should probably be $270 and not $50, right? Isn't the normal cost?
I would have to ask.
The court, Madam Clerk, on a misdemeanor bad check case, is it total of $270?
$270 and the cost of prosecution is included.
Yes, Judge. So I need to change that to $270 times 2. That was my error. I apologize.
Thank you.
So I'm sorry, that's 270 times 2. Okay, you see that?
Yes, sir.
Do you understand that change, Mr. Probation? You see that change? 270 times 2 instead of 50 times 2?
Yes, sir.
Sorry about that, Judge. And while we're walking back and forth, I failed to have him sign it. So it. Sorry, man.
Did you see that?
All right, man. So, Your Honor, there will be adjudication of guilt in 23 MM 798, which was the Ocean City bingo case. That will be the case remaining on Ocean City bingo, and then all the Ocean City restitution amounts total $1,260, and I'll announce them in a second, but they're being covered under 23 MM 798, and 23 MM 800 will be the one and only Mary Esther bingo case, and it will cover the total restitution of $850. The state is agreeing to dismiss 23 MM 801, 23 MM 803, 23 MM 804, 23 MM 806, and 23 MM 809, and that saved him a very large amount of court costs, so we thank the state for its willingness to do that. The state agrees not to file on the FTAs, no trespassing at Mary Esther bingo and Ocean City bingo, restitution as follows, and there is a proviso that state probation may allow offsets if he can provide proof of prior payment. There was some indication that maybe he had made some small payments on some of the restitution under the deferred prosecution, so that state probation can consider any proof he has on that. But we can go ahead and liquidate the amounts today. Ocean City bingo restitution will total $1,260. Mary Esther bingo restitution will total $850. Cost of prosecution, again, that's actually court costs, not just cost of prosecution. Do I need to write court costs, or so it'll be $270 times 2 on court costs, PD fees of $50 times 2. Transfer monetary obligations to 23 CF 199. He was previously adjudicated guilty in 23 CF 199. Dismiss the VOP, reinstate and modify to pay the restitution costs and fees from the misdemeanor cases as stated above. Otherwise, he's going to be required to complete his outstanding terms and conditions, and he'll have $150 in public defender fees in 23 CF 199.
State?
That's the state's agreement.
Okay. Mr. Davis, I just need to ask you a few questions. Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So just want to make sure we all understand, a little bit complicated deal, but I want to make sure you understand it.
Okay.
And because you're agreeing to it, and
Right.
I don't want to kind of mix you up. So you heard your attorney state the terms of your plea agreement that are contained in the written plea agreement that I see you've signed.
Yes, sir.
Have you been able to read this thing?
Yes, sir.
And you've
I've
gone
read it.
over it with your attorney to make sure you understand all the legal ins and outs?
Yes, sir.
Okay. Importantly, you're waiving the right to go to a trial on all these cases. This will be a final resolution of all these misdemeanor cases and the violation of probation.
Yes, sir.
Is that what you want to do here today? You believe that's in your best interest?
Yes, sir.
Okay. And you have had all your legal questions answered of this?
Yes.
Okay. Very good. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt in the 2 remaining misdemeanor cases, 23 MM 798, 23 MM 800. And the state is agreeing to dismiss 23 MM 801, 23 MM 803, 23 MM 804, 23 MM 806, and 23 MM 809. Correct, state?
Yes, Your Honor,
Okay.
that's the state's agreement.
And the state also agrees not to file on any failures to appear.
Correct.
Okay, so as a condition of this, so you're on your other probation, you're already on your felony probation, 23 CF 199.
Yes, sir.
Okay, we're going to dismiss the violation of probation. You're going to reinstate and modify that probation to include all the restitution costs of the MM cases. So there's two of those.
Right.
So the restitution in the Ocean City batch is $1,260, and then the Mary Esther bingo restitution is $850. Those are the two cases.
Yes,
So they'll
sir.
go into your violation, your probation on your other side of your felony. There's one felony probation that's going to continue.
Right.
So reinstate, modify to pay that restitution, plus all the cost and fees from the MM cases. And other than that, complete the original terms and conditions of your probation.
Yes, sir.
So, $100, $150 PD fees, etc. Okay. Any questions concerning any of that?
No, I just, when it's time to pay, I pay to my probation officer when I go see her monthly.
Correct. To make those payments would be paid to probation?
Yes, Your Honor.
Okay.
Okay.
Yes. Okay. Any other questions?
No, sir, and I thank you, and Merry Christmas to the courts and state.
Yes, Your Honor.
You feel better.
And Your Honor, this will take him off the docket. I think he had court yesterday in misdemeanor court, but this would take him off any future misdemeanor court dates. And Your Honor, may he report first thing in the morning to probation to restart his probation? Is that okay? Okay. I mean, actually, you were on community control, weren't you?
Yes, I'm about to be off that though in 4 months.
Okay, well,
Okay.
you report first thing in the morning. As soon as you, well, how do you want him to call as soon as he gets out of jail today? Because he's under community control.
He's not released after 3 o'clock. He needs to report tomorrow morning at 8 o'clock. Otherwise, he needs to report immediately at conference.
So if I get released before 3, call
Yes.
probation?
You need to come in probation.
Okay, and then after 3, then show up in the morning, okay.
Thank you.
This way, sir. All right, thank you.
Good luck.
Thank you.
Mr. George?
Your Honor, William Dorsey's before the court, docket 24, 23 CF 1548. From speaking with the state is looking at some information that I provided relating to Georgia out-of-state previous alleged DUI charges. So at this time, the state's not able to make an offer, not willing to make an offer that would get him out of jail, not willing to stipulate to a bond that would get him out of jail, and he needs to be continued to February 14.
Court will continue this matter to February 14th.
Your Honor, I'd like to apologize for yesterday.
I understand there's a lot of frustration. It's a tough time of year.
Thank you. Thank you, Your Honor. Your Honor, Mr. Nerion Dykes is before the court, docket number 2522 CF 29. I did meet with him earlier this morning. I just need a moment with him to make sure that nothing's changed, Your Honor. Your Honor, Mr. Dykes has advised me at this time that he's changed his mind and does wish to request to withdraw his plea. I've gone over disadvantages of doing that. I put them on the record last time and have again discussed that with him. He's indicating to me at this time that he intends to get a private lawyer to handle his case going forward. I don't know if he would prefer to ask to have this status continued out one more time.
Tell me what the status of the case is at this point.
The status of the case is that he received a 20-month DOC order and sentence on the
Right.
violation of probation, I immediately, within 2 or 3 days, realized that there had been a potential motion to suppress that I had not noticed because of the lack of time to look at some video that I got basically right around the time of the hearing. And so I filed a motion for status conference. This was continued over from, I think it was last week, for a status conference today. And I think it would be in his advantage if he was going to get a private lawyer to go over things with the private lawyer before he made a potentially lasting decision pertaining to his asking to withdraw the plea. But I also have this is the first time hearing that he's going to get a private lawyer. So may I just... He would prefer to have, if the court would allow it, if the state doesn't object, to have a short additional continuance so he does believe he's going to get a private lawyer to advise him in the situation. So I would ask to continue the status conference one last time to the January date. He would remain in custody here until the disposition of the motion for status conference.
Your Honor, the brief answer is I don't object. There are some things that I do need to look into if he's actually going to file a motion to withdraw his plea. Again, for the record, I do need to state that if he does file a motion to withdraw his plea, once we set a hearing for a motion to withdraw a plea, if his plea is successfully withdrawn, the state will not be offering a cap in this case, which the state did for the violation.
Okay. Very good. So we'll continue this matter until January 18th.
Can I ask a
question? That's going to give you a chance to get together with your attorney.
I'm still on the record as his attorney at this time until the public defender is relieved. I'm simply asking him what it is he wants to ask the court about, because even if he thinks it's not prejudicing him, I've had clients that make a mistake on that. So
He's so advised. If he wants to talk, he can talk. You want him to talk?
Yes, sir.
Raise your right hand. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
Oh, before you start, you understand this being recorded?
Yes, sir.
You understand anything you say can and will be used against you in a court of law?
Yes, sir.
Okay, fire away.
I just want to ask, why would the cap be taken away?
So they've entered into a deal with you.
Yes, sir.
They've agreed to a plea. Plea is like a contract between the state and say, we're agreeing to this.
Right.
So we're not going to trial. We both agreed, put the trial aside, we're going to agree on that.
Right.
You're coming wanting to withdraw that.
Right.
You withdraw that, the plea's gone.
Yes, sir. Okay.
That's what they said.
Understood.
Plea's gone. So there's no cap.
Understood.
No plea. We're going. You're back to square one.
Yes, sir.
Okay? That's what they're saying.
All right. Yes, sir.
Okay?
Thank you.
Your Honor, just would encourage Mr. Dykes, if he actually is getting a private lawyer, to have an appearance entered in the near future so he can be working on.
Try and meet with your attorney before the 18th of next month. So you got about a month. Try and get a hold of one and get in there and figure out where you're going with this, okay? We don't want to drag this out, indefinitely.
Yes,
okay?
sir. Thank you.
Thank you, Your Honor.
Thank you.
just have Ms. Cooper left?
Sir?
You just have Ms. Cooper left?
Yes, I think so, sir.
What about Stephen Briley?
Your Honor, the court may be aware that, I'm not sure if it was Your Honor's assistant or somebody else in the court administration, but there had been communication from Mr. Briley to the court, or an attempt, I think it was yesterday while I was here in court on other matters, by him asking if he could appear by Zoom. The response was that was not permitted, and I am not allowed to say what other communications we have had with the individual, but he does not appear to be present, Your Honor.
That's true. I do recall that we asked if he could appear by Zoom, and we said no. So where are we at?
I would ask for a continuance, simply because it is a matter of an expired VOP that I just hate to see the guy come back to jail when it probably can be resolved early next year. Would the court permit a continuance, one final continuance? It's a long expired VOP to January 18th or 16th.
State okay with it?
Yes, Your Honor.
Court will continue this till 1/16 without subpoenas in the morning.
Thank you, Your Honor. That'll give him plenty of notice to make arrangements.
Sure.
You ready for Cooper, Mr. Medina?
Cooper?
Your Honor, I have an offer from Ms. Cooper, and I need to write it up, but based on this offer, she would be able to get out of jail today. Would the court permit her to remain over to the afternoon if we're going to be here? If there are there any inmates here this afternoon?
Yeah, we'll have afternoon inmates.
Is it convenient to courtroom security to keep her over till 1:30? That might save time, and I could be writing it up over lunch.
Yes, sir. Will do.
That's fine.
So we'll bring her back, and I will meet with her at 1:30 and have the agreement all written out.
Thank
you, Your Honor.
Thank you.
Thanks, Judge.
Mr. Medina would like Ms. Cooper brought back at 1:30.
Okay, so it is 12:15. Let's try it. We'll come back at 1:30.
Yes, sir.
Thank you, Your Honor.
Thank you.